Yeah, I mentioned, my lord.
Yes.
My lord, I'm mentioning for motion, my lord. I'm from Delhi, my lord.
Ah.
Yesterday, I tried to file my writ petition, but I got late, my lord. I have a flight tomorrow morning. That's why I'm pressing that the matter.
Tomorrow,
Tomorrow, no, today, for today, my lord.
what is the matter about?
It's a writ petition, my lord.
Ah.
I was a government servant. I got terminated. Thereafter, I've fought litigation for 25 years. Ultimately, my money has been released. A small portion has been not released, my lord, of the pension, my lord. For that, I'm pressing, my lord.
Why before this bench, division bench?
It will be before
Single bench. You make a mention when the matter.
my lord, for that only I
No, since we are sitting in a division bench,
Oh.
moment we rise, you make a mention.
okay, my lord.
Okay, otherwise we'll permit it. You make a mention at when, because the procedure is you'll have to make a mention before a single bench.
Because of the time posting.
Informally, we are allowing it, but you'll have to make a formal mention. We'll have to maintain the procedure. Yes.
Wait, please. My lord, I would like to mention listing of the matter for tomorrow.
DB,
DV.
what is the urgency? We do not know whether we are having DB for other methods or not. What is the urgency? Tell me.
The incumbent already got retired. And
Okay.
he has not been given any.
What was the
benefit.
challenge?
My lord,
What was the challenge in this? Is I think writ appeal.
read it.
Writ appeal. In the division, in the single bench, your petition is dismissed.
No. I want the case. But government has prepared the appeal.
Government has preferred this appeal. Appeal has already been admitted.
Yes.
You want a hearing?
Yes.
We'll give the next, when is the next division bench will give there? We do not know. If only one matter, we may not see it also tomorrow. If you give the mention memo, we'll have a talk with the registry whenever it is, I think it will be a division bench
All right.
within.
May I Lordship? Lordship, I would like to mention item number 2, Lordship. Lordship, this matter may be adjourned for Lordship next Lordship on 14 Lordship. Next week, Lordship. My seniors have some personal difficulties today, Lordship. Tender matter, Lordship.
We understand, but everything is stayed.
Lordship, next.
A simple issue,
Yes, Lordship.
whether executive magistrate or
Yes,
a
Lordship.
judicial magistrate.
Yes, Lordship.
Either way,
Yes,
if
yes.
it is an executive magistrate, we
Yes,
said we allow it and send you, remand you back.
Yes, Lordship.
The
Next week,
public
Lordship.
work is stayed.
Yes, Lordship. Next week, Lordship. Next week, Lordship.
I cannot next week. The
On
public
14
work
Lordship.
is stayed.
Lordship picks the matter, Lordship. 14 Lordship.
Oh, we'll take up the next division bench.
My lord,
Yes, Lordship.
my lord, fund is also getting lapses, my public interest.
See, suppose it is by the executive magistrate.
Yes, Lordship.
Your thing is by the executive magistrate.
Yes,
Yes.
mine is in
So if
the
we there is no specification whether it is executive or judicial. Suppose we hold that there is no difference. So we'll remand the matter back and they will proceed with the work.
Lord-
Your writ appeal is allowed.
Lordship, my senior handle this
What
matter.
is the
Lordship.
happiness in staying a public project?
No, Lordship, I'm not for staying long
Just
pending,
next
Lordship.
division bench.
Next division bench, Lordship. On 14, Lordship, next division bench.
We'll
If
see,
14
maybe
is
day
there,
after tomorrow. Huh?
Much obliged. Interim maybe continue, Lordship. Next,
That is the main problem.
That is the main problem.
no, Lordship, next, Lordship,
But
please,
I can
Lordship.
understand, last time also Mr. Tara called me up, my lord, his personal problem, and I can understand.
Okay,
His wife is, I think, hospitalized.
okay, then it's as prayed for, release this matter on this, we'll have a talk. Release this matter on this, we'll take the date. Day after tomorrow.
14, if possible,
14th is what?
14, we have a DB.
DV,
14th, huh?
Tuesday.
Next Tuesday. No, next Tuesday, no, you'll have this week.
Yes.
This week,
Friday.
Friday.
We'll have a, not Friday, so we'll have a DB on Thursday. Thursday,
Thursday.
Deeply okay.
yes.
Okay. Continue, interim maybe continue. Much obliged.
Interim order pass earlier, sir.
Your Lordships, my lord,
Yes.
I would like to mention item number 3, my lord.
Item number 3,
Yes,
for,
my lord. Here, my lord, we have yet to receive instruction, my lord, and I have taken consent from the petitioner.
you have got a petitioner.
No, my lord, I've got the respondent, my lord.
We'll do one thing, we'll have to issue a notice to the Advocate General,
Yes.
isn't it?
Yes, ma'am.
No notice has been issued yet. No notice, so we'll issue a notice to the Advocate General as well as to the state.
Yes, ma'am.
Let the matter reach.
Lordship, I'd like to mention item number 19, Lordship.
Item number
19, Lordship. I am,
19,
yes, Lordship. I am for the private respondent, Lordship.
or not by me. This stress national highway recovery,
No,
huh?
no.
Oh, no, this is different, that is in single bench, sorry. Yes,
Yes, Lordship, item number 19, I'd like to mention, if any appropriate day of its honorable court, Lordship. Next time. will be
Can
there.
it be one of the next Tuesday?
next Tuesday, we do not know,
In that case, well, let it be after 3 weeks.
after 3 weeks. Let's wait for the learned counsel for the respondent.
Yes, Lordship, respondent number 5.
Respondent matter stays adjourned for three weeks.
Like this.
One of the, I was directed to file a compilation of the instructions. However, there was some technical difficulties because the registry was not accepting the compilation without there being a affidavit, my lord.
Without there being an affidavit.
Yes, it being in a affidavit form. So
Let us do one thing.
otherwise,
This matter is going on since July.
yes,
No
my-
notice has been issued,
yes, my lord, instructions were sought.
only on instructions. Some affidavits, pleadings are also filed by you.
No, my lord, only this submission of the compilation of instructions.
Hmm. So
Otherwise, action has been
one
taken.
issue is regarding lodging on FIR. Can it by an individual petitioner, can it be a subject matter of PIL? Other issue might have something. If you have lodged an FIR, if they are not registering, you have other options. It's not kind of a power. Anyway, we are issuing a notice and you file affidavit in terms of order dated 27/7/2023 and order dated 21/9/2023.
Yes.
Okay. Thank you.
Otherwise, in our compilation, we have said that all that has been offense report has been.
Whatsoever you
Yes,
have,
yes,
if
ma'am.
you have an affidavit so that he can respond.
Yes, ma'am.
Okay.
Yes, ma'am.
And what about the private respondent?
Private respondent, whether the, no, notice was not issued.
No notice was issued. How can we pass?
Yes,
All prayers are against an individual.
Yes.
Can we pass an order in a PIL without hearing? You are Mr.
Oh, Modi.
O Modi.
Yes.
Heard Mr. O Modi, learned counsel for the petitioner. Also heard Mr. N Ratan. learned additional advocate general
Yes, my lord.
for the state of representing state of Arunachal Pradesh. Full stop. Issue notice returnable after 6 weeks. As the state respondents are duly represented by Mr. Ratan, no formal notice need be issued. Full stop. Petitioner to take steps for issuance of notice upon respondent number 7 to registered post with AD as well as to Israel mode. Full stop. The state respondent is to file affidavit in terms of the order that is 27/7/2023 as well as order dated 21/9/2023. List accordingly.
Obliged, my lord.
Steps be taken, just right after steps be taken within a period of 5 days from today. Yes,
My lord, extra copies also, my lord.
okay. No formal notice need be issued, however, extra copies be filed.
Obliged, my lord.
Third, Mr. Saikia, Rintu Saikia, learned counsel for the petitioner, also heard MS Swenso, learned counsel representing the state respondents. The present petition is filed assailing amongst other the Rule 5 within bracket A of the Arunachal Pradesh State Food Commission Rule 2018 framed under clause F of subsection 2 of section 40 of the National Food Security Act 2013. Full stop. Admit, issue notice to the respondents as well as to the learned advocate general. Full stop. Notice on behalf of state respondents are accepted by so. Any private respondent?
No, no.
No. As the parties are duly represented, no formal notice need be issued. However, extra copies be furnished to the learned
Already
state
furnished,
to the learned state council within a period of 3 days.
And we have already furnished the extra copies.
Already furnished. Not necessary. Full stop. In the meantime, the respondents may file their.
Or in last occasion, when some instructions were sought from them.
No, when rule is challenged, you will
No.
have to admit it. This is the procedure. You will have to hear the advocate general.
Right.
Then only, it's not like other repetition. Yes, next. Dini, tell us, what about the delays?
Your Lordship?
Will condone the delay?
Yes.
Will not, should we condone the delay or will admit straight away?
Your Lordship may, while admitting, make a reflection in the order condoning the delay, Your Lordship. There need not
Okay.
be any petition.
Just look into the first phrase, huh? This is an appeal against judgment and sentence dated so and so, passed by so and so from the jail. From the jail to the legal services authority.
Yes, sir.
From the jail to the legal services authority. Full stop. There are delay of 46 days in preferring the appeal. Considering the fact that the petitioner, the appellant is inside jail, this court is of the view that such cause is the sufficient cause which prevented the appellant from approaching this court within a prescribed period of limitation. Full stop. Accordingly, delay stands confront. Admit this appeal, call for the records, issue notice, admit this appeal, issue notice, call for the records. Full stop. Call for the records. Registry to appoint one legal aid counsel to represent the appellant. Same in all the cases. Huh? See the delay and the period and record name of Jenny. Huh? I have marked it in every pages.
Deeply.
Okay, this will be up to
Up to
in the second case, delay is, just see there is written note is there. Huh? Up to item 13, then 15. Okay,
deeply.
Item number 14. Your Lordship, on item number 12, your Lordship. On plain appeal, your Lordship.
yes.
They have not annexed the, your lordship, sentence that, your lordship. They have not annexed all the documents required
So
for,
that they will give, will pass an order.
yes, your lordship.
That since we are calling for the records,
Yes, your lordship.
they will give a copy to the public prosecutor.
And your lordship, here the issue is, then since it has been filed through legal aid service, your lordship,
Ah.
they ought to have filed an application, your lordship.
What to
Because
have filed?
if suppose your lordship, it is come directly straight away from the jail
So
authority.
there is a notification from the notification number 32 by the Honorable Chief Justice, which says that even if it comes to the legal aid, it should be treated as jail appeal.
Okay, your lordship.
That's why this has come as jail appeal.
And but your lordship, where,
Otherwise,
where the sentence has not been annexed, there your,
we'll give a direction. I'll correct this order that all the relevant copies be
Yes.
furnished to the public.
yes, your lordship. Without that, your lordship, delay
Ah.
cannot be
Yes.
computed, your lordship. Obliged.
Item number 14.
Your Lordship, this is an IAF for condonation of delay of 168 days in filing the appeal.
Condonation of delay of
168 days in filing the appeal.
in filing the appeal,
Yes,
but notice is not served upon the respondent number 5.
Lordship, respondent number 5 will be a performer respondent. They are the one, they are the contractors who have constructed the road. The
If you
respondent,
say that you do not want respondent number 5, you will have to file an application.
Lordship, we have taken steps, but they are not found in the address which they were
Address
provided.
is office not found in the given address, return to
Yes.
the sender. So you'll have to find the address.
Lordship,
Or you have two options. Either you'll have to say that I will find out the address,
yes, Lordship.
or that this parties be deleted from the array of parties.
Lordship, we have tried 2-3 times.
No, that we
finding the-
understand. Then we'll have to say, make a paper publication.
They were a party in the writ petition, so for that purpose we have.
So you therefore, you
Yes.
either make a prayer that the respondent number 5 be deleted. We will delete it on your oral prayer, but at the risk and cost, your risk and cost, without entering into the merit. This is one option. Second option is you will find out the correct address and take a fresh step.
His Lordship.
Or
but they
third
have-
option is that you will file a paper publication.
Lordship, in this case, one more chance may be given, so I.
That will give, just, we are giving you 3 options.
His Lordship.
So you want to take a fresh steps
But
in a proper address.
the main respondents were all
No, that we
Yes,
understand.
yes,
What is the issue?
Lordship, this is an appeal against the judgment and order dated 8th of August 2022.
Again, you prefer the writ petition,
Yeah, we preferred the writ petition and the petition was dismissed.
dismissed,
Yes, Lordship.
and you
So
are the state respondent.
Yes, Lord.
How the respondent number 5 is related?
they are the contractor who have constructed the road.
And what is your grievance?
Lordship, for non-payment of the compensation for the land acquired.
So contractor is not a necessary party.
Yes, they are not a necessary partners.
The learned counsel for the petition applicant submits that the writ petition was preferred
Yes,
for payment of compensation for acquisition of land
yes.
for construction of
Trans Arunachal Highway.
transnational highway.
Yes. Transnational highway.
You have no recovery is there.
Lordship,
You have not been paid.
no lordship.
It is not related to recovery, na?
No lordship.
Okay.
This is
If it is
completely paid.
recovery, I will not take up.
Lordship.
What have you written? Construction of transnational highway. However, the said writ petition has been dismissed and present writ appeal is filed. And in filing the present writ, connected writ appeal, not present writ appeal, connected writ appeal, there are delay of
168 days.
168 days. The respondent number 5 was the contractor who constructed the portion of the transnational highway. Full stop. Accordingly, the learned counsel for the petitioner submits that for the determination of the dispute, the respondent number 5 is not a necessary party.
Yes, Lord.
Accordingly, the name of respondent number 5 may be deleted from the array of parties. Full stop. Consider the above submission. Consider the above submission as the matter relates to the non-payment of compensation. The contractor, in the considered opinion of this court, shall not be a necessary party. Full stop. Accordingly, the name of respondent number 5 be deleted from the array of parties. Full stop. Where have you explained the delay?
Lordship,
Paragraph.
lordship,
Which paragraph?
lordship, paragraph number 3.
The delay in approaching, we are condoning it. Delay in approaching this court is explained at paragraph
3.
3 of the present application. Consider the same, and this court is of the view that the petitioner has been able to show sufficient cause for approaching this court beyond the period of limitation. Accordingly, the delay stands condoned. Registry to register the writ appeal is already registered.
Yes.
Registry
Yeah.
to list this appeal for admission on next Friday.
I am also representing respondent number 3, and I have not been furnished with a copy of the.
No, that they will now furnish. Full stop. The petitioner to furnish the copies of the writ appeal to the state councils for the state respondents. Please this matter on next Friday. Not Friday, Thursday.
Lordship, we also need one extra copy.
It will-
No,
you
extra
give-
copy has
The
been
matter may
started.
be listed after 2 weeks, lordship, because the senior counsel, he will come from
Okay,
Delhi.
okay. The writ appeal be listed after
2 weeks.
2 weeks.
Meanwhile, extra
In the
copies may.
meantime, the learned counsel, she will have to.
Yes, lordship.
I'm not understanding how can the writ appeal be registered before condonation of delay.
Yeah, this is the process.
Hmm?
Yeah.
That cannot be.
Here they
The
registered.
writ appeal cannot be registered. Then its problem comes.
Yes.
Now, if it was not registered, it would not have been registered until and unless you serve copy to the state respondents.
Actually, we served the copy to the state before filing. So-
List the connected writ appeal after 2 weeks. In the meantime, the learned counsel for the appellant shall furnish the requisite copies to
Yes,
the state councils,
Lordship.
state respondents.
Lordship.
Okay,
Much obliged.
I stand disposed of.
Thank you.
Number 16.
Blade, may I please yawn? Lordship. Lordship, this
Third, the
application,
learned counsel for the petitioner, this is an application for condonation of delay of 9
9
days
days.
in preferring the connected writ appeal. Full stop. Issue notice returnable after after 6 weeks. As the state councils are represented by Swenso, no formal notice need be issued. However, extra copies be furnished to him. Full stop. The petitioner to take steps for issuance of notice upon respondent number 3 and 4. Isn't it?
Lordship.
3 and 4. through registered post AD as well as through usual process. Steps be taken within a period of 3 days. Same
Same, your lordship.
in 13 days next. 17, delay is 13 days. 3 and 4. Steps on 3 and 4, is that it?
Lordship, delay is same, your lordship, 9 days.
Delay is 9 days.
Yes, your lordship.
Okay, give the file. Yeah. According to you,
Because-
9 days,
Yeah, lordship,
but I said it 13 days.
lordship.
Why? How can I do a mistake?
13 days.
Huh? You have written as 13 days. See, I have not opened the file also.
76.
See, 13 days. 13 days.
Because lordship, we are challenging the same impugn order, same.
Maybe there is a delay because you have by hand you have corrected it and signed it.
Of like,
You have not corrected in your file.
of like,
So I am correct. You are not.
sorry.
Here also notice, made the notice condonation.
No respondents.
Here.
Same read comparably 89 days. Steps
Yeah.
both ways.
No. Of like.
This to work. Try your level best.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 17 to 20.
The item number.
Supplementary list, my lord, that
Yes.
is recovery of,
These.
Hearing.
yes, my lord.
Yes,
17.
yes, 17 to 20, yes. All are analogous matter,
List
Lordship.
before any other bench without.
Appropriate.
Yes, Lordship.
Likha tek.
Yes,
my
Lordship.
Likha tabo.
Yes, Lordship.
Likha maz.
All likas, my lord.
Only guys.
No likha. List before any other bench without me.
Much obliged.
Your lordship, I beg to mention an unlisted matter.
What is the urgency?
Your lordship, I have been transferred out after joining my present posting place for 4 months. Arbitrarily and illegally on the behest of some political influences, I have been transferred out. So they have asked me to join the new posting place within 7 days. Therefore, I have filed this, your lordship.
When the order was issued?
Order was issued in 28th of this October. I had filed a representation since I had to file representation within 1 week.
Okay.
Obliged.
But only one condition. Not come back and will not wait.
Obliged.
If list is over.
Obliged.
Then all tomorrow.
My lord, the matter has been listed by mistake in the motion stage because the motion has already been done on 3rd of October this year. In the same case.
Huh?
In the same case,
In
the
same-
motion has already been done on 3rd of October.
But
Yeah.
motion is already done.
Here's the order. Order.
Similar.
Yes, similar case, same case.
How can be two same cases? You say similar cases.
Okay, similar case.
Huh? But there is no order like this here. Four 2020. Yes, what is this? What is this order in the record? And you have given an incomplete order. This is an order 310. Huh? But this is something different. Which are none has represented them. No, notice has not been issued. Notice has not been issued. Huh? You are
Yes,
Mr. Sonar.
yes, I'm just representing him.
Huh?
I'm on the behalf of Mr. Sonar.
What is your name?
Titaji.
Art, Mr. T. Dasi, Learned Council for the petitioner. And
I'm for respondent number 1 and 4, Your Lordship.
respondent number 4, 1 and 4. And M. Kato.
I'm D. Kandavulos. For
you are
respondent number 2 and 3.
number 2 and 3.
Yes.
Number 2 and 3. And who will appear for 1 and 4?
I'm saying
1 and 4. Then you are for
2 and 3.
2 and 3.
Yes, Lord.
And what about 5 and 6? R. Saikyas, Learned Standing Council for 5, 6 and 7. Who is for 5, 7? M. Kato.
It should be M. Kato, Lordship.
M. Kato, 5 and 6. And R. Saikya for the respondent number 7. Sailubago. Issue notice. This is an application. The writ petition is, present writ petition is filed. Assailing that the land of the petitioner has been acquired under the Balipara/Tirap/Sadia Frontier Tract Zoom Land Regulation Act 1947, whereas the petitioners or petitioner?
Petitioner. Yes, petitioner.
Petitioners.
No, petitioner.
Petitioner
Yes.
is entitled for compensation under the Fair Compensation Act, under the Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Issue notice returnable after 4 weeks. As the respondents are duly represented, no formal notice need be issued. However, extra copies be furnished to the Learned Council for representing the respondents within a period of 5 days from today. In the meantime, the respondents may file their affidavit in opposition. This is not called issuance of notice. Last order is not a notice, no notice was issued. Yes, next.
Much obliged.
Yes, who is the real department?
May this matter be listed on Tuesday, next Tuesday, sir, for instruction, so that entire matter may be disposed of.
You have the instruction and we are having it on Friday. Until then, no work order.
In that case, I am challenging the.
What is simple? You have notified that class 2 and 3 contractors will be eligible.
Yes, ma'am.
He specifically says that I am class 2 contractor. He annexes
Yes,
copy. There is a corrigendum.
Yes, ma'am.
And now he says I have been rejected. There is no order of rejection. It is a verbal.
Oh.
So you have instruction whether his tender has been rejected on the ground that he is a class 2 contractor as LS.
Madam, I am challenging the maintainability of this writ petition. Whether the writ petitioner can file this writ petition, madam. Whether the writ petitioner can file this writ petition, madam.
Why?
Madam, may I?
It's a proprietorship firm.
Firm, yes, madam.
Proprietorship firm represented by its proprietor.
Power of attorney, madam. Power of attorney.
Maybe he has given.
But whether he has been given any right to file a suit, madam. This writ petition, madam. In the power of attorney, madam. That has to be seen.
We will examine that. We will examine that. You have a fresh power of attorney. You will do illegality and you will question the technicality. Don't forget that you are in a read court.
Madam. Tuesday, my lord.
The present writ petition is filed with an grievance that though the petitioner is a class 2 contractor and qualified in terms of the NIT published on is eligible to participate in the tender process in terms of NIT published on 19 August 2023, read with the corrigendum dated 21st of August 2023, being a grade class 2 contractor. However, his tender paper has been rejected on the ground that he is a class 2 contractor. Full stop. From the material available on record, it is seen from the Annexer A that the petitioner is registered as class 2 contractor under the CPWD. Full stop. The NIT dated 19th of August 2023, whereby bids were invited for supply and procurement of materials under MG Enrega 2023-2024, isn't it?
That's
2023-2024. For 2024, nowhere discloses that what kind of contractors, what class of contractors are eligible to participate in the aforesaid tender. Subsequently, by Annexer O, a corrigendum was issued and it was specifically rectified that due to clerical mistake, the class of contractors were not notified. Accordingly, the class 2 and class 3 contractors were made eligible to participate in the tender by way of the aforesaid corrigendum dated 21st of August 2023. Full stop. In that view of the matter, if the tender of the petitioner has been rejected on the ground that he is not eligible being a class 2 contractor, prima facie is in violation of the tender conditions. Full stop. That being the position, the learned counsel for the petitioner, respondent department shall obtain instruction and apprise this court on the next day speaks why the tender paper of the petitioner has been rejected. Full stop. List this matter on Friday.
14, March. Tuesday, March.
Not Tuesday, Friday.
Alert.
Friday. Tuesday we do not know. Then we'll issue a notice returnable after 4 we can stay.
No, Malad. After a week.
No, Friday.
Or else
these are the important public works.
Yes.
You'll have to need an instruction over. You can take it. We can take it up at 2.
Yes, Malad.
Have the instruction over telephone.
I have.
Why his tender is rejected?
Yes, Lord, sir. I can take this.
You have a written instruction. Obtain a written instruction and apprise this court. Full stop. List this matter on Friday. 10th of Swenso. Till then, no work order shall be issued in respect of not the all.
Not Lordship. The package 3, Lordship. The
In respect
CD
of
block.
package 3 relating to
CD block, Lordship. A CD block, Surly, Lordship. Package 3.
Item number,
Lordship. The 2 is for package 3, Surly, Lordship.
2 in respect of Sarli.
Surly,
Sarli.
package
And in respect of Sarli block package 7.
3, Lordship.
Package 3.
Lordship.
Sarli Beg package 3.
Lordship.
Now what about the others?
3 is for CD Polosang package 8, Lordship.
Package
8.
Package 8 Polsang.
Polsang.
Okay.
Okay.
Huh? Package 8 Polsang. POLOSANG. Item number 3.
Lordship.
Then item number 4.
Item number 4 is the Lordship. Is for same package 3 for Surly, Lordship. All the
Package
different-
3 for
Surly.
Sarli.
Lordship.
Okay. Package 3 for Sarli. And 5
Is for Polosang, Lordship. Package
Polsang. So on two
2,
parts.
Lordship.
Just give the item wise block number and package number.
Lordship.
Huh? So that order is not necessary.
Lordship.
Give us the reason.
Well,
That much. We
Deeply
don't
obliged.
want to stall public project. Yes.
Deeply obliged.
Notice the table. No notices.
Please, my lord. This respondent number 1 yet to file the reply.
Yes,
2 and 3 already filed.
there is another requisition, is there it? Oh, no. But tell me, what is your right to continue in a quarter?
My lord is, I think, taking up wrong point also.
Quarter ka nahi. Tanira Milk.
This is item number
6.
Item number 6. Okay. This is a wrong different. Eviction for public premises.
Correct.
Yes. Who need to file affidavit?
Respondent number 1. The land
There is
department.
another requisition pending. Or some earlier order was there.
Actually, appeal is pending before the deputy commissioner. So it can
No, there is, you kindly come to the first order 17.8 says earlier requisition WPC 297 AP 2020.
No, sir. In that, I think he was not, the petitioner was not a party.
But are you having the order of 17.8?
Annex, Lordship. Because,
No.
let me-
See, I'll read. Just listen to me. The order passed on 78 by this court, not by this court. Anyway, in this court, it reads like this. If the earlier requisition number WPC 297 AP 2020, the issue was whether the land in question is private land of the petitioner and it was a land of government. And in furtherance thereof, there is a stay order of the court. And in compliance, therefore, the eviction notices were recalled. It would be unacceptable in now law to change the color of the eviction notice. So it means you have earlier approached by WPC 297 AP 2020. What happened to that?
No, Lordship, that matter is still pending, Lordship. That matter is still pending, Lordship.
Preferred by whom?
Preferred by the other individuals of the same area, Lordship.
Same area.
Yes, Lordship.
So let these two matters be taken up together.
Correct. Take it,
Huh.
Lordship.
Then only because whole stay order is passed on the basis of the earlier order, isn't it?
Correct.
Okay, who needs to file affidavit?
Respondent number 1, the land department.
Land Department Secretary, Lordship.
Yes, come.
Secretary land.
Yes.
You take some time?
Yes, sir.
Okay. The Land Management Department, the Learned Standing Council for Land Management Department prays for and is granted
3 weeks, sir.
3 weeks time to file affidavit in opposition. It is submitted that similar matters relating to the same area pending same area being WPC 297 within bracket AP/2020 is pending before this court, and same may be taken up together along with this writ petition, in as much as the interim order was granted in this case by this court on 17/8/2022, relying on the earlier stay order passed in the aforesaid writ petition within bracket WPC 297 within bracket AP/2020. First of, in that view of the matter, let both this matter be take together and listed after 2 weeks and be listed after 3 weeks.
Obliged. Grateful.
My lord has,
What is your right? Tell me.
yes, lordship, I have,
And a project is
I-
stalled.
I fairly admit, lordship, I do not have irreversible right to extend the
If
same.
you have indivisible
policy.
right, they are giving you a quarter. You are not happy with the quarter, take the HRA and go back, go your home. And for you, a project for construction of quarters,
Yes, madam.
quarters cannot be
For
stalled.
their own accommodation.
It
will be
cannot be stalled.
given-
For one person. This is not equitable.
Lordship, we are not saying that we will not move out from the quarter which we are in occupation now. But the alternative accommodation, lordship, that has been provided to us. lordship,
Where is your right to have an quarter under your service law? We are 30 judges. We are having 4 bungalows.
No, lordship, the
And
issue,
for that, HRAs are given.
lordship, issue involved is not that only, lordship. The issue involved is, lordship, there is too many quarters across this capital region. Those,
You want a good quarter.
those quarters were built in the year 1960s, but these are not demolished. We have been lordship.
Who are you to say that? First, you say us that this is my right to have a very good quarter. Establish that right. We will direct them, give him this grade group A, group B, type A, type B, type C quarter. Give him a bungalow. Show us how your right.
That lordship,
You don't have any
Yeah.
right. And for that, we cannot stall. You have option either to stay where the accommodation is there or to take the house rent. Or withdraw this writ petition.
lordship, may then kindly say that, lordship, after the completion of this
Definitely,
project,
your
lordship,
cases will be
we-
considered.
that's-
In our affidavit, we have said it's for them, we will give them first priority.
we should be
We'll
brought back,
record
lordship.
that, we'll
But
record
ex-
that, we'll record that.
And again, lordship, they have not specified what kind of quarters they are building, lordship.
You will,
Lordship
you
has seen,
will
lordship,
get,
that
you will
petitioners-
get quarter as per your status, If you are a secretary, you will get as per your, we cannot apprehend.
Since
A
they are-
secretary's quarter, secretary to the Department of Home. If you are a peon, you will get as per peon. If you are not given a peon's quarter, then come to us.
lordship, may kindly.
Three option, dismissal. And second option, withdrawal on the 14th, their statement that they will be given.
Yes.
And we will observe that in that view of that, it is closed. That as and when quarters are be completed, they will be given their quarters as per their
Entitlement.
entitlement.
And in addition to that, lordship, kindly make an observation saying that HRA will be given to
That is not,
petitioner.
needed, required to be said.
Government is.
That will observe that why we are closing this.
There-
No way out.
On that line, lordship.
And you
may
have
pass out.
enjoyed since. And see who will pay this escalations to the contractor. Who will pay the escalations to the contractors that they will say that you have not handed over the site. So we'll claim escalation. We are supposed to now every day there is rise of prices of cement, rod, everything. Who will pay this?
In fact, lordship,
No, nothing. This case, it's a case for dismissal with cost.
lordship, may kindly dispose of the matters, observing that the petitioner shall be entitled for HRA and on
No,
the
no, we will
completion
not
of the
say
quarter,
anything.
lordship,
We'll
they will
say
be
that-
allotted.
we'll say that this is then we'll have to enter into the merit. Then if we enter into the merit, we may have to observe what we think that it should be observed.
In fact, lordship, till now,
No,
till
we
then,
have
they
no
have not even.
problem hearing you. You argue your case.
Lordship,
You argue your case. No
Lordship,
problem.
lordship, has it, lordship has what is there in the petition, Lordship has got it, Lordship. So therefore, there is no, this advising argument, Lordship. Now only my only prayer is that Lordship kindly dispose of the matter, making an observation that on completion of the quarter, they will be allotted quarter as per their entitlement, and HRA will be given to the petitioners.
The heard Mr. D. Kamduk, Learned Counsel for the petitioner, also Mr. Sorry for
Pita Formula.
Kamduk, Learned Counsel for the
Respondent number 2.
respondent number 2. The petitioners are, what are you doing?
Lordship, they are
Different-
employed in different department, in different capacities.
The petitioners are employees under the respondent.
Government of Arunachal Pradesh.
Huh?
Government of Arunachal Pradesh, Lordship. They are not
Okay,
serving in
for
single
different
department.
different department.
Yes, different department.
The petitioners are employees of different departments under the government of Arunachal Pradesh. And they have been under occupation of government waters allotted to them at A sector Itanagar. They are aggrieved by a vacation order dated 25/4/2023 issued by the director within bracket housing government of Arunachal Pradesh from the quarters.
Yes.
They are in possession on the ground that the government is proposing to construct a multi-story residential building in place of the existing government quarters at A sector within Itanagar allotted to the petitioner, and the petitioners are sought to be shifted to another place / building which has been specifically built for urban poor people. Full stop. The basic grievance of the petitioners is that though they have been given alternative accommodation, but those alternative accommodations are not in good condition, and they are not in those quarters are not quarters, those alternative accommodations are not fit for living, not fit for human habitation. It is the further case of the petitioners that the aforesaid accommodations, alternative accommodations given has been constructed for basic service for urban poor, whereas the petitioners fall in the category of person living above poverty line. And as such, the alternative accommodation granted are not at par with their status and as per their status. Full stop. The respondent department has taken, where is the affidavit? A specific stand in their affidavit that paragraph
Paragraph 6, Malab, we have said. And page 4, Malab. Once the flats are completed within a period of 1 year, a petitioner will be shifted to new flats.
that you have taken the project somewhere. I have seen that you have taken the project for construction of the flats. Where is that?
Yes,
Huh?
it starts same, Malab, para 6, Malab.
No, that why you require, there is a statement. That place, that multi-storied building will be constructed. Okay, it is a specific stand of the housing department that the quarters of various sectors / colonies of Itanagar were constructed more than 50 years ago. And these quarters are now old and in bad condition. And therefore, the government has taken a planning to construct new, modern, multi-story flats in place of these old quarters for government employees in phased manner. Full stop. It is a specific stand of the state respondents that in the first phase, a cluster of type 2 quarters at A sector, Itanagar, where the petitioners are presently residing, has been approved by government for redevelopment. And the employees of A sectors whose quarters have been sought to be rebuilt will be accommodated in those flats with additional facilities such as parking space, common garden, and secured compound area and play space for their children. Full stop. From the aforesaid, it is seen that a development project has been taken by the government for construction of the quarters for the employees like the petitioners. Full stop. Such projects can only be halted only when the same shall infringe any vested and concluded right of the petitioners. Full stop. Admittedly, the petitioners are government employees, and it cannot be said that each and every employee under the state are having vested and concluded right to have quarters / accommodation given by their employer, in as much as the employees are given HRA for not providing quarters to them. In that view of the matter, it is also well settled that for issuance of a writ of mandamus, legal vested and concluded right is sine qua non. Full stop. This court is of the considered opinion that being a government employee, the petitioner shall have no vested and concluded right to continue to stay in the quarters which the government is proposed to demolish and rebuild phase quarters, that too in a specific stand taken by the government that those quarters are made for the employees, including the petitioners. Full stop. In view of the aforesaid discussion and reason, this court finds no merit in this present writ petition. Accordingly, same stands dismissed. However, it is needless to say that if the petitioners are not happy with the alternate accommodation, they shall be at liberty not to avail the same and avail the HRA instead.
My lord, since all the petitioners, they are having their own family, they will take time to
At this stage, the learned counsel for the petitioner submits that the petitioners may be given some time to vacate their quarters.
At least 1 month, Lord,
To which the learned counsel for the housing department has not objected. Accordingly, it is provided that the petitioners shall vacate their quarters within a period of 1 month.
Lordship, already it's got so much of delay.
No, no, but that's
No,
true,
I-
but we cannot throw out to the state also, they will have.
15 days, my lord.
Huh?
15 days.
We'll give him them
But,
one
my
month.
lord, they will
One-
depend on the alternate accommodation. Each person has been given 4 units, my lord. Now, if they don't want it, 4 units, your lordship.
My lord,
I
it's,
kindly appreciate.
Within a period of, you have waited for so much
Yes.
within a period of 1 month. The interim order passed earlier stands vacated. If the petitioners, the petitioner, no, not permitted, na? The petitioners, upor je dilu, the petitioners, agote dibo, no prayer. The petitioners shall vacate their quarters within a period of 1 month from today.
Yes.
Today, full stop, they shall be at liberty not to avail the accommodation given to them. Instead, they, in that event, they may be given their due HRS. Yes. Right.
Much obliged.
With the aforesaid petition stands closed.
Yeah, you.
Yes.
In this case,
You have already been evicted.
we have been evicted. The house also has been demolished. However, the order by which we have been evicted itself is illegal because it has not taken place in accordance with law.
Why?
And because we had not been given the chance of fair hearing. Although a notice was issued, our reply was not taken into consideration, and we were evicted without hearing our side.
No hearing was taken.
No hearing was taken.
Lordship, I am on behalf of Standing Council for Health Department. And the Standing Council is because of some difficulties is attending some other case in other court.
Okay.
This matter may be fixed on 9.
I've also just received the affidavit of the state government.
Okay, since seeking an adjournment, yes, who are you?
Lordship,
But
Respondent
an
number one,
appeal lies. There is an appeal lies to the district judge, is not it?
we have filed for the appeal also, but that has also not been taken into consideration.
Appeal is also dismissed.
Yes, Your Honor. And moreover, they are constructing over the land. And the petitioner
What about
has
the contempt
Lordship,
on 9th? 9th is a Friday,
9th is Thursday.
huh?
Thursday.
Thursday, Mr. Dickey will argue cases. No other cases. Thursday, 9th. Okay, so let us see on 9th.
I'm appearing on behalf of 1 and 2, Lordship. Affidavit, unfortunately, we have just served her now only.
9th for final disposal.
Okay, on the prayer of the learned council for the respondent number
3.
3. The matter stands adjourned and be listed on 9th.
Highly obliged.
Yes.
More than a year.
Where is the reason?
No, not even the memorandum of charges, madam. More than a year. No memorandum of charges.
Day after tomorrow.
Day after tomorrow. What what affidavit is you produce the record? How you have extended the?
No.
What will you get by putting them under suspension? Tell us. Except paying them public money without work.
Close.
Is that it?
That part is there.
They have not even furnished the memorandum of charges also, my lord, in violation of Ajay Kumar Chaudhary, 90 days. In any case, my lord, this is an offshoot of that APPC scam. We are nowhere connected actually.
Whatsoever, if you are connected also, there is a other
Yes.
mandate you have to follow, that's all.
But it's an admitted fact that we are not connected because we are not even in the examination cell. It's
Day
the
after
Public
tomorrow.
Service Commission, my lord.
Day after tomorrow. We'll allow on day after tomorrow. Day after tomorrow. We have passed some judgments, me and Justice Borua, allowing and giving reasons interpreting Ajay Chaudhary. That's why we are fixing on day after tomorrow. We'll have those orders. This is the wastage of state exchequer. Put them in any other place so that they.
We were in the Public Service Commission. Because of this public hue and cry, what they did is
I understand, I've seen.
they suspended everybody, even the sanitary worker also, the driver also. And we are no longer in the Public Service Commission. We have been transferred to the Secretariat now.
So that liberty will give. You will
That
be,
already been done.
you will be at liberty to place them in any other place where you think right. That will give.
That they have already done, my lord.
Okay, then they have to move. Yes, item number
My lordship.
13.
My lordship.
Yes, in view of office note dated
Yes, sir.
6/11.
Resistance has already been taken.
2023, await service report in respect of respondent number 5. Yes, next.
Lordship, there is interim order, lordship.
Interim order passed earlier shall continue. Yes, no counter affidavit.
Yes, my lord.
Yes.
And my lord, here, my lord, respondent number 60, my lord, respondent number 4, my lord.
And
Here, my lord, in respondent number 4, they have written, my lord, Deputy Commissioner Dibang Valley, District Rowing, but it should be Anini, my lord. It's wrong in the cost
Okay,
title. my lord.
That may be corrected.
Okay. It is submitted by the learned counsel for the petitioner death.
Respondent, my lord. For the respondent.
We will give the blame on him. Learned counsel for the petitioner death. The respondent number
4, my lord.
4 has wrongly been described as Deputy Commissioner.
Dibang Valley, District Anini. It
Dis-
should be Anini, my lord. They have written Rowing.
District Dibang, the Deputy Commissioner, District Dibang Valley, Rowing.
Rowing, yes, my lord.
Whereas instead of rowing,
It
it should be
Anini.
Anini. Accordingly, the learned counsel for the petitioner prays that he may be allowed to correct the same by hand. Prayer is allowed.
And my lord, after 4 weeks, my lord, we
Prayer
have yet
is,
to receive.
prayer is
instruction.
allowed, full stop. The learned counsel representing the respondent number
1 and 4, my lord.
1 and 4 prays for and is granted
4 weeks, my lord.
4 weeks time to file affidavit in opposition. Full stop. Awaits service report in respect of respondent number 5. Full stop.
Obliged.
List accordingly.
May, lordship. Lordship,
4, 5, 6.
yes, lordship. Step taken, lordship, and service completed, lordship, through the dusty service, lordships. And my learned friends maybe appear.
Respondent number 3. But what about
Lordship, here respondent number only 3, lordship. Government.
only 3?
Yes, lordship. Lordship, here is the case, lordship.
Service is complete.
Yes, lordship. Lordship.
So we can fix it in the admission.
Yes, lordship. Next week, lordship.
No, my lord,
If
we have
possible.
yet to receive instruction, my lord.
Because lordship, here is lordship project work is halted, lordship. As because of the lordship small matter, lordship. NHR lordship page lordship 33, lordship.
What is your grievance?
Grievances, lordship. Here is the case, lordship. Private respondent, lordship, made a complaint against me, lordship, against the petitioner, lordship, for distribution of property, lordships. They private respondent claiming that he is the son of the petitioner, lordships, and for distribution of property, lordship. On that basis, lordships, complaint is made to the additional deputy commissioner, lordship, Mechuka, lordship. Additional deputy Mechuka, while directing the village authority to hold the cover, hold the project lordships, tender work, lordships, which is illegal, lordships. Have no jurisdiction to pass such order, lordships.
Yes.
Well communicate, lordship.
What is the project?
Project lordship, constructions of lordship. By additional.
You are the contractor.
Link road.
No, lordship. I am the power of attorney holder, and I am the power of attorney holder.
Power of attorney holder of whom?
Lordship.
Power of attorney holder of whom?
Power of
Whose power you are holding?
lordship. Power of attorney, lordship. I enclose, lordship.
Forget about enclose.
Yes.
You are holding whose power?
Power of contractor lordship.
Contractor?
Yes,
that is
lordship.
what, you are the contractor?
Yes, lordship.
Maybe power of attorney, but you are
Yes.
the contractor?
Yes, lordship.
You have been awarded a work.
Yes, lordship.
Now the work is being halted by the deputy commissioner.
Yes, lordship.
Now who is the department who awarded you the contract?
Lordship, PWD lordship.
Yes, who is representing PWD?
Lordship,
Not
here
PW,
lordship.
RWD.
RW, sorry.
RW, who is
RW.
for RW?
Lordship, here
Civil council.
RWD lordship, we not made a party lordship. It's
Yes.
because lordship order while providing the complaint lordship.
But they should support you, come and support you, that yes, this is our project anyway. So who will pay the cost of the escalation? Who has filed a complaint? Okay, we'll provide that. If the repetition is allowed in that condition, the respondent number 3 will pay the compensation, and that is to pay compensation to the government. When, tell me the affidavit. And what affidavit is required? You bring the record of the deputy commissioner.
Lordship, I have been recently instructed to appear.
Okay, since he is appearing today,
Yes,
we'll have to definitely
Yes,
adjourn.
yes, lordship, but lordship fixed that may be given lordship.
You will give a fixed date.
Yes, lordship. For final disposal lordship.
After 3 weeks.
The present,
After 3 weeks lordship is too long lordship. Project is half lordship.
just a minute, wait. Because we'll have to see the record, na?
Yes.
Under what authority they have passed, because it's a writ of certiorari. No affidavit is required. We'll certify the record.
Yes.
We'll see the record. If it is correct, it's correct. If not correct, we'll set aside. MS and Anju Learned Council has entered appearance on behalf of the respondent number 3. Full stop. Respondent number 3. And praise for
3 weeks.
no 3 weeks. This is a project. You are the beneficiary. Your affidavit is not important. Praise for 2 weeks.
2 weeks lordship fixed that may be given. lordship.
2 weeks time to file affidavit. Full stop. Prayer is allowed. The Learned Council representing the Deputy Commissioner and
One and
additional Deputy Commissioner Mesuka
Yes, ma'am.
shall produce the record wherein the impugn order dated impugn order number syllable MK/JUD page 1 issued by the ADC Mesuka was passed inasmuch as by the aforesaid order the ongoing construction work and payment of bill for the link road from Dusi Gang to Sekhar village has been stalled till settlement of a dispute raised by the respondent number 3. Full stop. As the matter relates to a public project, this court is of the view that this matter shall be decided at the earliest. Full stop. Accordingly, matter be listed on after 2 weeks give a date. 23 November 2023. Okay, 23 November 2023. If no record, will please assure.
Yes, ma'am.
Huh?
I'll bring.
Okay,
Much.
please record.
My lord, as per the order dated 13/9/2023.
456.
Yes.
Huh?
Petitioner have served a notice to Dusty, and I have already filed affidavit.
4, 5, and 6.
Yes.
Where is that? Affidavit you have filed?
Yes.
I could not find it out. Where have you filed it?
This morning, my lord, I have filed.
Oh, then it will not be there. It is submitted that notice upon respondent number
4, 5, and 6.
4, 5, and 6 has duly been served through Dusty, and an affidavit has also been filed. the affidavit is not on record. I will registry to take the same and list day after tomorrow. List after 2 weeks we go.
May I plead with Lordship?
Yes, what is this?
Lordship, this is a 2020 matters, my lord. So kindly this may be disposed of today, my lord. This is regarding, my lord, payment of compensation in regard to Greenfield Airport at Holongi, my lord. All the land owners, my lords, they have been adequately compensated, my lord, except me, my lord, because of wrong numbering of the plot number, my lord. Lordship, in the year 2009, my lord, I purchased a plot of land from this respondent number 6, my lord, and he had 2 plots. So out of the 2 plots, I purchased one from him. And when the assessment was done, my lord, the name of the owner of the plot was wrongly recorded, my lord. So I filed a complaint before the authority, my lord, to rectify the correct name of the owner, my lord. That is in my favor, my lord. So on the basis of my complaint, my lord, this respondent number 6 was issued a notice, my lord, for hearing. There is an annexure 4, my lord, page 20. So accordingly, this respondent number 6, my lord, he appeared before the competent authority, my lord. But after this notice on that day, the competent authority, they did not conduct any hearing, my lord. So after this notice, my lord, no further notice has been issued, my lord, in spite of my repeated representations, my lord. And rather, my lord, they have claimed
What is the stand of the respondent number 6 is your vendor?
Yes, my
From who is the respondent number 6?
Lordship.
You sold the land to him.
Yes, Lordship.
And who now money is paid to whom?
Lordship.
None of to us, my lord.
Huh? See, what I could understand is that prior to acquisition, you purchased a plot of land from him.
Yes, my lord.
Your name was not recorded in the land record.
Yes, my lord.
So accordingly, you have not been paid the land acquisition compensation.
Yes, my lord.
Now, to whom the land acquisition compensation is paid?
The respondent authorities, my lord, they are contending that they have paid the compensation to respondent number 6, my lord. Which
Yes,
is not
what
true.
you say, Mr. Respondent number 6. Have you received the compensation of the plot of land he has sold?
Lordship, I have received the compensation with regards to plot number 126.
And what is his plot?
The plot which I have sold to the petitioner is plot number 111.
And who received that 111?
111 compensation, even I have not received, since this particular plot was sold by me way back in the year 2009. And accordingly, since there was confusion.
Now, whom you have given? Who is the authority? Deputy Commissioner?
Lordship, but however, there is no record. I mean, as such in the entire, I mean, affidavit in opposition also, where I'm not denying that I have not been paid compensation. I have received compensation with regards
according to you.
Yes, Lord.
You admit that you sold the plot of land to him.
Yes, Lord.
And you also say that the plot I have sold, for that I have not received compensation.
Yes, Lordship.
I have received compensation from the remaining land.
No,
Is your case?
Yes, Lordship.
Some other land.
Some other land.
Some other land.
Yes, Lordship.
Now, what is the stand of the government?
Government, Lordship, as far as I am concerned, I have not received anything. But however, with regards to government, it's
any government has shown any proof that has been transferred to you?
No, Lordship. Just they have enclosed ground assessment report, Lordship.
Yes, government. To whom you have paid? What is your plot number?
111, man.
Lordship, from the beginning, the private respondent number 6 name is Lordship recorded in
No, that we understand. Sometimes what happens is that suppose a plot of land is sold, name is not recorded. So definitely notice will be issued to the
Original
person
owner.
whose name is recorded in a record.
Yes.
That we understand. But the person, if he comes and says that yes, no, in fact, this is a mistake. I am the owner. This is my sale deed. I have purchased from him. You have a duty to decide on that. Whether you have decided that, that is the issue.
What we have said is that the compensation has been paid to this person.
Any proof thereof?
Lordship, we have
If you have paid to him, then you will have to file a suit for recovery. We will record everything, then you will have to file a suit for recovery. We cannot give a direction in a repetition. Isn't it?
Yes.
Yes.
Or my lord, this notice, my lord, at annexure 4 may be given effect to my lord, because after issuance of this notice, no hearing has been conducted as on today, my lord.
No, but now this will be now putting the horse somewhere else, because they have already paid.
Yes, Lordship.
Now suppose they decide also. They suppose decide, no, you are entitled. Now how you will recover from then that you have paid to him? How will you will recover it from him? You will have to file a civil suit.
That's
Reed court cannot decide.
yes, Lord.
Exactly, Lordship.
That is the difficulty.
Lordship,
Or you will have to file any reference before if the deputy commissioner not decided before the land acquisition appellate authority. Reed court cannot decide. He is saying that I have not received. Government is saying that we have paid to him. Everybody admits that he admits that this land belongs to you. He says I have not received. Government says we have paid it. How can we decide it?
Lordship, there is nothing on record which demonstrate that government has paid the compensation amount with respect to plot number.
And you have
11.
taken a specific stand that you have not received that
Yes,
amount.
Lordship.
Have you filed affidavit?
Yes, Lordship.
Have you taken a stand that you have sold the land, plot number 111
Yes,
to him?
Lordship. I have.
Have you taken a stand that I have not received any amount for them?
Yes, Lordship.
Amount for that part.
Yes, Lordship.
Now government makes a statement that we have paid. Any proof of payment?
Lordship,
So far 111.
in this matter, Lordship, since my colleague is not in the government anymore, Lordship, he was dealing with this matter. Lordship, this matter can be taken up after a week, Lordship.
Okay.
So that I can go through the.
You go through it.
Because-
See, here
Yes.
issue is simple. The landlord, he says that I have purchased it from him.
Yes, that
That is
I'm aware.
admitted by himself. So
Yes,
a Reed court can take note of it. This is an admitted fact.
Yes,
You
Lordship.
have annexed your sell deed?
Yes, ma'am.
Sell deed. He has annexed your sell deed. He says that I have not received money for compensation so far relating to 111, but I have received so far relating to my other land, which are also acquired. Now you say that we have paid him. You will have to specify and show us that you have paid him for 111 also. What was the land you have received compensation? 126.
126, Lordship.
He said that I received 126. You will have to satisfy this court that you have paid him for not only 126, for 111 also. If you can show that, then we'll send him to the civil court. If you cannot send it, we'll first send the liability upon you and direct you to pay it to him.
No,
That's
Lordship,
all.
8 per hour paras, what we have said is his name was entered and signed himself against plot number 111.
If you produce the record, show us that he has received.
Lordship, I need to discuss with
You
the
have it.
concerned officer also, so that I can do the hearing
Okay.
properly, Lordship. I can.
Heard the learned counsel for the parties. The basic grievance raised in the present petition is that the land of the petitioner within bracket plot number 111
Yes.
Yes.
has been acquired along with other plots of land belonging to other persons, including the respondent number 6. Respondent number 6
Yes.
for construction of Holongi
Airport.
Airport. Full stop. It is the case of the petitioner that he purchased the plot number 111 from the respondent number 6 in the year
2009.
2009. Though record was not corrected, though revenue record was not corrected. Such stamp has been admitted by the respondent number 6. It is the case of the respondent number 6 that the respondent number 6 sold the plot of land 111 to the petitioner in the year 2009, and the respondent number 6 is having another plot of land being plot number 126, and he has received compensation in respect of plot of land number 126 only, and has not received or paid any compensation. So far, the same relates to plot number 111, which he already sold to the present petitioner. However, the state authority has taken a stand in affidavit that they have paid compensation in respect of plot number 111 to the respondent number 6 also. However, no specific material has been produced before this court. In that view of the matter, on the next date fixed, the state respondent shall produce record/proof to show that they have paid land acquisition compensation so far relating to the plot number 111 also to the respondent number 6. Full stop. The learned counsel for the state respondent prays for 2 weeks' time for such purpose. Accordingly, matter stands adjourned and be listed after 2 weeks, and on the next date fixed, the learned counsel shall produce such proof of payment of land acquisition compensation in respect of plot number 111 to the respondent number 6. If they cannot produce, we will pass a different order. If they can produce, you file a civil suit against him, saying that this is the document, recover it.
Lordship, can we have a fixed date here, Lordship?
Yes, please this matter on
Thank you.
Wednesday.
No.
29 November.
29 of November.
29th of November.
Deeply okay.
This is the issue. I think
Yes,
so.
Lord.
This is the issue. If he has taken, then he will, if he returns back, admits that I will return it back, then we will not relegate. If he says, no, I will not return it back, then he will have to go to the civil court. Is that it?
Yes.
Yes.
Deeply
Okay.
okay.
Lordship, here in this matter, I would, before my friend starts, Lordship, they have a standing counsel here, Chief Secretary through Commissioner Power, Lordship. The petitioner herein was the employee of Power Department. So they have a standing counsel. Most probably he have not been served a copy.
Yes, no, it has been, sir. I think council was carrying it.
Now, what is your case? Tell me.
My lord, I was the head of department, chief engineer power, my lord, in 1995.
Just a minute, just a minute.
Oh.
Issue is very limited, my lord. I have been released pension and gratuity, but 1/3 portion has been deducted, my lord, for which government has taken advice from Arunachal Pradesh Public Service Commission, my lord. And it is, the observation is on page number 35, my lord. This is the government order, my lord, has it?
Just a minute. Yes, we'll have to issue a notice.
Yes, Lordship.
We'll have to issue a notice because we cannot pass a straight away an order. You are at least getting something.
Yes.
But at least we wish
Allah,
that
they-
during his lifetime he gets something.
Yes. Two-third Lordship has been
He
issued
is
already.
now
Two-third is
80.
issued, he's
Yes.
82 years, he's
Yes, ma'am.
fighting senior citizen, so we'll have to give a preference to his case.
Please, madam.
Lordship,
Forget,
this-
we'll
this
not, we are not
two-third-
commenting on on merit.
Yes.
But as a senior citizen, if he's entitled, law will be same for all, but he needs a preference in the queue.
Lordship, we agree
So
very much.
that much, at least you should assure that you will file the affidavit or response within a specific period of
Yes.
time.
Notice may be issued. Lordship.
Huh?
Date may
It
be
is-
fixed, my lord.
You say a date.
My lord, in which month, my lord?
Yes, madam, it is a special case because he is a senior citizen. We are not saying that we'll allow his petition
Yes.
because
yes.
he's senior citizen. We'll decide on law, but he needs a preference.
Any month, which month you wanted it?
I think end of this month will also be.
In the first week of, no, not December, my lord. In the last week of November, if possible, my lord.
Give a date as per your convenience.
30.
30.
or 20.
Any Monday, my lord, I would prefer any Monday in the week.
Give a
Yes,
date
ma'am.
as per your convenience.
Monday is November, there is holiday. No, it's
My lord, 30th
28.
will do, my lord.
30th of November.
30th November or
Okay.
29th November. whatever. 30th
Heard
November.
Mr.
Sudhir Pandey.
Sudeep Mandi, learned counsel for the petition also, heard also learned counsel for the respondent number
1 and Lordship, 1 and 3.
1 and 3, and you are
Lordship, 1, 3 and 4.
1, 3 and 4.
Yes.
And how many respondents?
Sorry.
Huh?
Preparing on behalf of L Parme department.
Respondent number 2,
2 and 5.
2 and
2 and 5.
For forwarding.
L Parme, he is here.
Pending on.
Standing counsel L Parme for respondent number 2 and 5. The present writ petition is preferred assailing an order dated
This is not, my lord, order dated
22/12/2021.
No, 25th 11/2021. 25th November 2021.
25 November 2021. 2022. 25th of November
2021.
2021, where is the order?
Yeah, on page
Page-
number 35.
35.
Page
Lordship.
35, no? 25th of November 2021, within bracket annexer 6, whereby in exercise of power under rule 40 within bracket 1 of the CCS within bracket pensions rules 1972, the petitioner was made entitled only 2/3 of pension and gratuity or both, and maximum of food pension and gratuity or both. Full stop. Full stop. Issue notice returnable on 38th of November 2023. Full stop.
Ali Oblast.
As the petitioner is a senior citizen, aged about 82 years,
Yes.
and claiming for his pension, this court is of the view that the respondent shall file their affidavit on or before the aforesaid date.
Ali Oblast.
Obliged.
On or before the aforesaid date. Full stop. The petitioner, as the respondents are duly represented, no formal notice need be issued. However, extra copies of the writ petition be served upon the learned counsels representing the respondents. When? Within a period of?
My lord, I will do it within a week, my lord.
Within a period of?
Copies I will serve you today itself, I will do it.
You serve the copies today itself because we are giving a fixed date.
Yes.
Uh,
It's illegal.
For today itself, I will just, I will arrange. it.
Extra copies within a period of 2 days. Full stop. List accordingly.
Ali Oblast.
May I submit your lord?
Yes, who is the respondent?
Respondent is standing council and one private individual, Your Lordship. Your Lordship, I am aggrieved by the transparent posting order dated 27 October 2023, which is in page 24 of my petition.
We need a respondents. Bring them.
Yes, I have served the copy to respondent.
They must know that you are moving it unlisted.
Yes, Your Lordship. In fact, I have told him yesterday, Your Lordship. Your Lordship, the matter herein is that I was.
No. Just without the respondent, how can you pass and stay order?
Your Lordship, this is a case, Your Lordship. The case herein is
your transfer order is of 27th October.
Yes.
You have been asked to join within 7 days, meaning
Yes.
hereby 28, 29, 38, 31, 1, 2, 3, 4.
Yes.
Now today is
7th.
7th.
Your Lordship, in this regard, I have filed a representation also. Actually, the case herein is I am a contractual teacher under Samagra Shiksha Yojana. The teacher appointed herein are non-transferable, Your Lordship.
Where do you get that?
That is in annexure number 1, Your Lordship. We are appointed as per by walk-in interview. Annexure number 1, Your Lordship, 22, page 22. Yes, annexure number 1, page 22. In the third last line, Your Lordship, this is appointment order given to us here. No
Where is that note? You cannot
see,
be transferred.
Your Lordship is in the third last line. No representation for change of posting place shall be entertained under any circumstances.
No, that is no place of posting. That you are
Yes,
not.
Your Lordship, while appointing us, we have been told that we are appointed on the basis of, on the needed basis of the
Where is the
school.
impugn order?
Impugn order is page 23, Your Lordship, page 24, annexure 3. And as per verbal communication, while submitting my representation, the officer therein has told me that we are not transferable. This has been done mistakenly. And now I am the.
You are Bali Potom.
Yes, I am Bali Potom. And it's in the mid of academic session, Your Lordship. I have been transferred to Alo.
Now you said that you have been some 4 months and all. Where is that?
Yes, it's 4 month. Annexure number 2 is my joining report.
Annexure number
2, page 23. Page
Yes.
23. This is my joining report at Alo. This is my first posting place. And as per the teacher's recruitment rule, Your Lordship, I cannot be transferred in a single year twice.
Where is your contract?
Your Lordship,
Your contract.
my contract is annexure number 1. This is the order.
No, contract to be contract between you and the government.
That has to be produced by the education department, Your Lordship.
No, you have signed it, isn't it?
Yes, I have signed it, but then that copy is kept
Here,
with
the
the.
service of Sri Bali Potom shall be governed by contractual agreement executed between Bali Potom State Project Director Samagra Shiksha dated 17 May 2023.
Yes.
You must have a copy of that.
Your Lordship, that is kept with them. We are contractual teacher, Your Lordship. We have been only given this appointment order. And may I take Your Lordship to annexure number.
We'll list this matter tomorrow.
Your Lordship, may I take
Nothing will happen.
May I take Your Lordship to annexure number 5,
Okay.
page.
Okay. Listen to my order.
Yes.
The present application is filed assailing an order of transfer dated. Order of transfer dated. Where is that?
27th October 2023, page 24.
Order of transfer dated, page 24, huh?
Yes.
Order of transfer dated 27th of October 2023, whereby the petitioner was transferred from Khas Pakam Alo to Khas Khamba Alo, same Alo.
Yes, it's
What
same.
is what is your problem?
My problem is that your lordship, as per this
Okay.
teacher and post.
Okay, the matter is more permitted to be moved unlisted.
Yes.
However, none appears for the respondents. Accordingly, list this matter tomorrow,
Yes.
showing the name of the respondent councils. Full stop. Till tomorrow, the transfer order so far relating to the petitioner shall not be given effect to.
Obliged.
Till tomorrow. We'll
Obliged.
see tomorrow what is your right, what is the alo and what.
Okay.
Till tomorrow,
Okay.
এটা ফটকে করে দেব।
Obliged.